Hello my dear friends, welcome back to my YouTube channel. Myself I am Lavkush Jogi. I have completed MSc in Agriculture, Seed Science and Technology, Specialization Seed Science and Technology from HNBJ Central University, Srinagar, Uttarakhand in 2020. I have got 52 rank in PhD program Seed Science and Technology from Indian Council of Agricultural Research ICAR All India Entrance Examination for Admission in 2021. Today I am going to tell about the topic Rights in Protection of Plant Varieties and Farmers' Rights Act. Introduction. Under the Trade Related Intellectual Property Rights TRIPS agreement, it is obligatory on part of member to provide protection to new plant variety either through patent or an effective generous system or combinations of these two systems. In many countries, such varieties can be protected through breeder rights, patent and above International Union for Protection of New Varieties of Plant Convention. Above is observations of Union for Lay Protection Days Obtention Varieties Union for Protection of New Varieties of Plant. It is an international convention which provides a common basis for examination of plant varieties in different member states of above for determining whether a plant varieties merits protection under above or not. India was therefore under a obligation to introduce a system for protecting new plant variety. India opted for so generous system for protection of varieties by three important notification wise act, rule and legislation. All the three are enclosed in the book. In place of patent, protection is provided to the varieties of under PPV and FRA in India. A patent in a exclusive right granted by a country to the owner of an invention to make, use, manufacture and market in innovations provided the innovations satisfies certain condition stipulated in the law. Exclusivity of right implies that no one else can make, use, manufacture or market the invention without the consent of the patent holder. This right is available only for a limited period of time. However, the use of exploitations of patent may be affected by other law of the country which has awarded the patent. The Protection of Plant Varieties and Farmer Right Act 2001 received the assent of the President of the 13 October 2001. The Act has 97 sections distributed over 11 chapters. The Act contains provisions of protecting the larger public interest which safeguard to farmer by giving farmer rights researcher by providing researchers right along with a effective system of protection of plant breeder right. The farmer right include his traditional right to save, use, share or sell his farm produce of variety protected under this act, provide the sales is not for the purpose of reproduction under a commercial marketing arrangement. The Protection of Plant Varieties and Farmer Rights Authority has been set up at New Delhi to administer the Act. The Protection of Plant Varieties and Farmer Rights rules was notified by the Department of Agriculture and Cooperation, Ministry of Agriculture, Government of India, New Delhi on 20 September 2003. It contains 76 clauses distributed over 9 chapters with 4 schedules, 12 plant variety registry form and 33 plant variety forms. Protection of plant varieties and farmer right regulation was notified by the Department of Agriculture and Cooperation, Ministry of Agriculture, Government of India, New Delhi on 7th December 2006. It contains 13 sections distributed over 4 chapters. Objective of the Act. Objective of the Act. The PPVFR Act was implemented to stimulate investments for research and development both in the public and private sector for the developments of new plant varieties by ensuring appropriate returns on such investments. It will also facilitate the growth of the seed industry in the country through domestic and foreign investment to ensure the availability of high quality seed or planting materials to Indian farmers. Apart from this, the Act will be also recognize the role of the farmer, cultivators and conservers and the contributions of traditional, rural and tribal communities to the country agro biodiversity by rewarding them their contribution through benefit sharing and protecting the traditional right of the farmer. The Act is implemented by PPV and FR Authority for protection of new plant varieties if required of safeguard right to breeder, farmer and researcher. Protection. Protection means nobody other than the concerned breeder or institute may commercialize or registered variety or produce, sell, market, distribute, import and export the seed, the commerce of the registered variety without proper prior authorization from the breeder institute developed by the variety up to 15 years for the crop, 18 years for tree and vines from the date of registration. Protection of new plant varieties. On request of the breeder and Act provide protection to new varieties that may be extant varieties including farmer varieties, the varieties of common knowledge and essentially derived varieties. The each classes is defined under the chapter variety. Varieties with following bottlenecks cannot be protected under the first, not capable of identifying such variety are. Second, consists solely of figures are. Third, is a liable to mislead or to cause confusions concerning the characteristics value identify of such variety or the identity of breeder of such variety. 4. It is likely to deceive the public as or causes confusions in the public regarding the identity of such variety. 5. Is comprised of matter likely to hurt the religious sentiments respectively of any class or section of the citizens of India. 6. Is prohibited for use as name or emblem of for any of the purposes. 7. Is comprised by solely or partly of geographical name. The Act does not provide protection of plant varieties that carries genetic use registration technology and terminator gene. The protection of plant varieties and farmer rights may be protected new varieties, extant varieties, essentially derived varieties, farmer varieties, varieties of common knowledge landrace may not be protected, not identifiable, consists solely of figure liable to mislead or causes confusion to in identification, identity of breeder in questionable. Its protection may be hurt the religious sentiments provided for use as name for the any purpose comprised of geographical names involved gold or terminator gene may be protected procedure. Submission of application seed candidate variety expressions of grouping traits list of similar varieties and fee. Publication of the application for objection, dust testing, examination of result, publication for protection. Rights breeder breeders right of the variety for 15 years oblique 18 for tree and vines. Commercialization of the registered variety, total control over formal marketing of the variety may authorize other person for right similar right on EDV. Researcher rights registered varieties can be used formally for research to develop new varieties. For repeated use a parent authorization certificate is required. Farmer rights to be get protection on the varieties as a plant breeder, save use or resow, exchange, share or sell the produce as seed compensations on poor performance, protection against in assent infringement. The important points of the Protection of Plant Varieties and Farmer Rights Act 2001. Examination procedures. The procedure of examining a variety for protection is based on novelty present in the candidate variety in commercial sense and distinct nomenclature based on expressions of the morphological characteristics listed in the national test guidelines of the crop, uniformity in the expressions over the population and stability in the expressions of distinct traits over the year and locations. Novelty is not essential but distinct nomenclature is important. NDS test. Endus test. Novelty plant variety is novel if at the date of filling of the application for registration for protection the propagating or harvested material of such variety has not been sold or otherwise disposed of by with the consent of breeder or his successor for the purpose of exploitations of such variety. First, in India yearly than 1 year, or second, outside India in the case of tree or vine yearly than 6 year, or any other case yearly than 4 years before the date of filling such application, provided that a trial of a new variety which has not been sold otherwise disposed of shall not affect our right to protection. Distinctiveness. New plant variety will be considered distinct if it is clearly distinguishable by a least one essential characteristic from any other variety whose existence is a matter of common knowledge in any country at the time of filling of the application. Uniformity. In new varieties, a new plant varieties will pass uniformity test if subject to the variation the many we expected for the particular features of its propagation. It is the sufficiently unformed it is in its essential characteristics. Stability. New plant variety will be considered stable if its essential characteristics remain unchanged after repeated propagation, or in the case of particular cycle of propagation at the end of each such cycle. Compulsory, compulsory plant variety demarcations. After satisfying the above four essential criteria, every applicant shall assign a single and distinct denominations to a variety with respect to which he is seeking registration. The right to farmer. As per section 39 in chapter 6 of the PPVFR Act 2001, following right have been provided to farmer. As a plant breeder, a farmer may breed or develop a variety and get protection for without any registration fee. Farmer engaged in a conservation of improvement of genetic resource of land, race and wild relatives of economic plant is initiated for recognitions and reward from the gene fund if the conserved resource is used as used of donors of genes in development of registered variety under the act. Use of seed. At the global level, of the first time, India Act provided right to a farmer use the seed protected variety in the same manner as he was entitled before the implementations of the Protection of Plant Varieties and Farmer Right Act 2001. The Act permits of a farmer to use, sow, resow, exchange, share or sell the produce as seed even of protected varieties. But the Act does not permit a farmer to use the protected brand name for sale of seed. Compensations. The expected performance of the protected variety under the given condition has to be disclosed to the farmer. In the event of failure in the performance of the protected variety under given condition, the farmers may claim compensations as per the prescribed manner. Protection against infringement. Section 43 specifies that the farmer cannot be prosecuted for infringement of rights specified in the act of he can prove in court that he was unaware of the existence of such a right. The right to plant breeders. An exclusive right of the breeder or his successor, his agents, to commercialize or the registered variety either the his her own person or through anyone he designates, to produce, sell, market, distribute, import and or export the variety. In short, breeder has full control over formal marketing. The breeder of the protected variety has right for 15 years, 18 years for tree and vines from the date of registration. A breeder may be authorized any person to produce, sell, market or otherwise deal with the variety registered under this act. The breeder of essentially derived variety has the same right as of new variety only after authorization by the breeder of the initial variety. Right of researcher. Under section 30 that falls in chapter 4, the right of researcher is mentioned. It provided following right to a researcher. Researcher can be freshly use any registered varieties for research, even to develop new varieties. Authorization from the original breeder of The protected variety is required for repeated use of the protected variety as parental line to develop new varieties. Benefits sharing. Any citizen group of citizens of India or governmental organization or NGO firms formed or established in the India can claim PPVFR authority to assess and determine claim compensations may be any from for commercialized protected variety. National Gene Fund to credit inter alia benefit shared under the Act of local community level to use the fund for facilitating sustainable use of genetic resources. Compulsory license. After 3 years from the date of registration of protected variety, any person can apply to PPV and FRA authority for undertaking production, distribution and sale of the seed of other propagating materials in the event of non-availability or short supply of the seed or other propagating materials or non-availability at the reasonable price by the breeder or institutions license. Then the PPV and FR Protection of Plant Varieties and Farmer Rights Act authority in consultations with the central government and after hearing both the parties may pass an order for registered proprietor to grant the license to the applicant for undertaking production, distribution and sale of the seed are per the rule for determined period of time. This is known as compulsory licensing. The compulsory seed productions license may be provided when breeder or institutions are licensee of the protected variety. The planting materials is not supplied or short supplied. Charge prohibitively high price for planting materials. Plant variety tribunal may also provide compulsory license to expedite disposal of related legal disputes.